Happy Friday. Seems like we went back into winter this morning. I saw this post that said, "Come on, spring already, just fight back, spring." kind of made me laugh because I thought, yeah, we got a lot of snow today. Anyway, so I wanted to talk today a little bit about agency. I've had a few questions, and I even saw one transaction this week that had some violations of agency. And so I want to make sure everybody's clear on what agency is and some of the pitfalls and some of the things that we need to be aware of as we're working through our agency. So really there is three kinds of agency that we deal with. Okay, we've got agency, buyer and seller, listing agency, where we're listing the property, we're representing the seller, we represent the buyer, and then there's a limited agency. Typically when we get into problems, it's limited agency, so we'll spend a little bit more time on limited agency today, but I'm going to touch on a little bit of them first. So one of the biggest misconceptions is in the state of Utah, we have a law that says only a principal broker can be the agent to the public. So that is because of that law that's put in there. That's why everything is written under the principal broker. So our principal broker is Russ. So he is actually the agent of all of the clients, all the listings, all of the buyers, everyone that you get. He is actually the broker for them. That's why he's called the principal broker. He is the the broker for the public. Now, under Russ, he has sub-agency. Sub-agency is where the agents come into play. That's where you come into play, where we authorize and give you permission to represent the principal broker in the transaction. So we have that question come up a lot when, you know, agents will either leave the company or come to the company and they want to move their listings. It's not that we won't let you take the listings. It's a matter of there's a process. There's a process that has to be followed, and we can easily do that. So it's a matter of just understanding where that connection is. The confusion that we see a lot is in limited agency. So we have an agent in our company representing the seller and another agent in our company, different agent, representing the buyer. We still have to have limited agency signed and disclosed because the principal broker is limited in this transaction, even though the buyer has their own agent and the seller has their own agent. So that's why we have to go through all of those disclosures when we're working within our own company. Now, buyer and seller both need to agree to that. So if they don't agree to that and it's in the company, then we have to work out some other solution for it. But because the broker's limited, and we'll go into what they're limited with, that's where we have to have all of those disclosures. So that's one thing that we miss a lot. The other thing is when you don't represent somebody. So it's an unrepresented buyer or unrepresented seller in the transaction. So our job and our fiduciary is to our client, the one that we have signed the contracts with. However, what we have to make sure we're aware of is that just because somebody is unrepresented doesn't mean they don't have protections in the process. So I'm going to give you a few of the protections that they need to have, which means if you represent the seller and a buyer comes to your home, they're going to purchase the property, you decide that instead of represent them as limited agency, you decide to have them as a non-representative. So there's an advantage to that. I mean, I'm going to go through the two advantages. One is if you have a limited agency in that situation, you need to treat it as two transactions, which means you need to have all the buyer's documents, all of the disclosures, everything signed into your dot loop. If you're representing the buyer, same as with the seller, you've got to have all of the documents signed for there. If they're not represented, then we don't need to have all of those disclosures because we're not representing the buyer in that situation. So you'd only have one transaction in dot loop when there's a non-represented buyer. If you are representing two, you'll have two transactions in dot loop. Okay, so here's some of the protections. So let's say that I represent the seller and I have an unrepresented buyer that comes to my property and I decide, I don't want to do all the paperwork for them, they're going to represent themselves. These are the things that they have that they are still protected. Okay, number one is, so that basically what the law says is that the buyer needs to beware, indicating the parties without an agent are responsible for protecting their own interests, which that's why we're not representing them. However, this does not leave them unrepresented person without any protections. Okay, there's 5 of them that protect them. Number one is a defect in the property must be open to observation or discoverable on reasonable inspection. That is, defects must be covered up, or that is, defects must not be covered up or concealed by the seller. So if you are representing the seller and you know some defects, and I've had agents say, well, they're not represented, so I don't have to worry about telling them about certain things because they're on their own. They don't have protection. That's not true. We need to make sure that if it's that we're not concealing or covering up or anything. Number 2, the buyer must be able to have unimpeded opportunity to examine the property. So I've seen this before where because the buyer decided not to do an inspection, the seller says, well, if they're not going to do an inspection, then they can't come look at my property. I'm not going to let them in. And without having an agent to defend them and say, hey, no, we can come in and look at the property and examine the property. If we take that approach, we're going to be in violation of impeding their opportunity to look at the property. Okay, number 3, all material defects in the property or in the principal's ability to perform must be disclosed. So anything that affects your client that's going to affect the buyer needs to be disclosed to them. So if there's anything in the transaction that's coming up, that still needs to be disclosed. Number 4, the principal and the agents and all sub-agents must not engage in fraud. Obviously, I hope that's a self-explanatory one, that we're not involuntarily or voluntarily entering into fraud. The interesting thing is even involuntarily entering into fraud is still looked at as fraud. So you've got to be aware of what's going on with the transaction. And then the last one, an agent has the duty to the customer that he will be honest, ethical, and competent in that transaction. So I've seen it a few times where the seller's agent says, well, I don't represent the buyer, so they're good luck for them and they're on their own. So we just need to be careful that we're not impeding what they want to do in this process. That will help. Does anybody have any questions about an unrepresented buyer in a transaction? Okay, so let's move on to limited agency. This is the one that I find gets the most people in trouble, is the limited agency. So there are, we have different fiduciary duties that we have as an agent that we have to do with our clients. So just real quick, let's see if anybody knows what those 5 are. Does anybody know what they are? Anybody get it?
Okay, do you want me?
Can we get one?
Oh, go ahead. Keith, is that Keith?
No, this is Aubrey. You can go though.
Go ahead,
Oh,
Aubrey.
go ahead. We'll do it. Why don't we do it together?
Yeah, sure. I'll do obedience.
Okay, there's 1.
Full disclosure.
Full disclosure. 2.
Confidentiality.
Confidentiality. That's 3.
Loyalty.
Loyalty, yep.
Yep. 4. And then the last one,
Reasonable care.
reasonable care and diligence. Right. Okay, so those are the 5, and then there is a 6th one that we have to deal with, but it's more of dealing with our responsibility to hold safe the accounting and the money. So we need to make sure we keep track of the money. So let's go through these real quick so that we kind of know what the responsibility of them are, and then how they affect us in our limited agency. So the first one is loyalty. Loyalty is a duty to act solely on the best interests of the principal instead of on others' interests. So we find this one is typically happens with, we had this problem back when we were having multiple offers, and maybe you guys had this experience before where you were showing some buyers homes in the morning and then a different buyer homes in the afternoon, and then you're crossing over and showing the same type of property. So you've got to be really careful. We had to be really careful back then that you didn't favor one client over the other of your own clients. So you have to be really careful and disclose that have another client that is looking at the same property. Now, we don't see that as much as we did back last summer, but that was one of the issues that brought in this loyalty and brought a lot of ethic complaints that we weren't following our fiduciary duties with loyalty. The other one is if you as a principal decide that you want to buy the property and a client of yours that you have a signed buyer broker agreement with, if they decide they want to buy it, does anyone know what you're supposed to do with that? So I give it to my client and they say, I'm not interested in it. And I say, well, that's a good deal. I'm going to buy it. And then the next day they call up and they say, actually, you know what, now that I'm thinking about it, I think that is a good deal. I'd like to buy it. Does anyone know what happens in that scenario, or does anything happen? Does it matter because they said no at the first?
Yes, I would say it does matter. You'd need to refer it out to another agent.
Okay, you need to refer it out to the agent. So in this particular case, let's say that I am wanting to buy the property myself and I have that relationship. Can I just refer that client out to somebody else, or do I have to do something different? Does anybody know?
I do not know. That's a good question.
I would say
Okay,
you
so-
just have to disclose.
Yeah, so you have to disclose for sure, but let's say that I go ahead and put it under contract, and somebody that I have an agency relationship with decides that they want to buy it. What the challenge is this loyalty is their interest has to be above my interest as the agent. So if I have a
That's
signed,
what I was gonna say.
yeah, if
I
have a
would
signed
step out.
agency- Yeah, go ahead, Amy.
No, I would step aside. There's
Yes.
no way I would compete against a client ever.
Yeah, so the only way you could refer it out is if you didn't have agency established with that client. But if you have agency established with that client and you're wanting to buy the property, their needs have to go above your needs. You would need to back out of that contract and your client could go into that contract. So as much as, that may or may not be fair, and the agency relationship and the fiduciary duties of loyalty puts their interest above ours in every situation. So we need to make sure that we have that. That's one that I see that can come up as well. Okay. The second one is obedience. Obey all lawful instructions of the principal. If instructions are given that are illegal, the agent must withdraw from the relationship or be prepared for the legal consequences. So I see this one mainly with fair housing. When a request by your seller is in violation of the fair housing, we have to, the situation that we run into is we have an obedience fiduciary duty, but if it's against the law, then we have a duty to withdraw from that, not to just be part of it. So we need to make sure that we back out of it. So if we tell our sellers, hey, you can't do that, and they end up doing that, but we still represent them, then we still can be in violation of the law that was being broken because we have that obedience. So it's a really touchy situation when you talk about fair housing, where as agents, we need to take a really hard stance of, if you're going to go down this path, seller, I cannot represent you, or buyer, if you're going to go down this path, I cannot represent you. So that's one that's really big when you see a violation that they're doing. If they're asking you to do something that's not illegal, then we do have the fiduciary duty to do what they're asking us to do. Does that make sense? Okay, full disclosure, our obligation to tell the principal all material information is learned about the customer, the property, or the transaction.
I'm sorry,
Material fact is-
Jason. Can I ask a question about the previous number?
Obedience.
Well, just about when you're working with the seller, I had a buyer several years back, and I did not know that he had a record, but he did have a record, and we made an offer, a really great offer to a seller, and they came back and the agent told me, well, she looked him up and found out he had a record, and so they don't want to work with him. They don't want him to be in this neighborhood.
Okay.
So how would you handle that?
So the question would be is, I mean, depending on what fair housing violation are you thinking that he's violating?
Well, I mean, it's discriminating.
Okay, but we're discriminating against certain things, and there's certain protected classes. So
That's not one of them.
It depends on what they're discriminating against, because a criminal record doesn't necessarily mean, like, just because he has a criminal record doesn't mean I need to accept the fact that they're going to move into my house unless it's based off of one of the protected classes. That's what we're more worried about. So if they're making a decision based off of he has a record and he's a single person, well, then now we're discriminating against the single person, not necessarily the record. So it really is kind of the gray area of what are they discriminating against? And I mean, you can discriminate against a lot of things and be okay with it, but you can't discriminate against things that are protected.
Yeah, that's not protected. It was my understanding while I was in that position that we literally had no say in it. That was that.
Yeah. Yeah, and that's.
So can I ask if they're on the sexual offenders list, they have to disclose, but that's on them. I don't think we can discriminate if they have gone through the legal process, but that's a question, because that's a touchy subject. I don't know.
Yeah, I mean, obviously they have specific rules based on being part of that they've got to disclose. That's on them for disclosing that. But as far as the agents are concerned, I'm not familiar with what the rules are for a sexual offender and what they can and they cannot do. That's specific for them. We're talking, in this particular case, we're talking about, unlawful things that our sellers are asking. Like, I don't know what the rules are on there, Rebecca. So I don't know what the sexual offender.
I'm not aware of any real estate rules. I know they have to be registered on the state registry, but I'm not aware of anything to do with real estate.
Yeah.
Me too. I don't think there's anything. Of course, if
I'd
it's
be more worried
not
about-
taken care of.
Yeah, I'd be
If
more
they
worried
haven't
about the
gone
other
through due
protected
process.
classes and being like, I mean, we've all probably been around someone who's discriminating against one of the protected classes. If your client is involved in that, you've got to be very clear with them that that is not okay, and that if they're going to proceed down that road, that you can't represent them, and we need to back out of that representation. Because what it's basically saying is, if you are representing them, they are breaking the law, they were breaking the law, and you continue to represent them, that doesn't exempt you from the problems that will arise from it. Okay. All right, so number 3, full disclosure. We're talking about material facts that are relevant to the person making the decisions. This could include the physical condition of the property or the ability of the buyer to make the payments to the seller. If the seller's doing seller financing or something like that. Any of that is material facts. We have to make sure we're full disclosure. Number 4, confidentiality. The agent will not disclose to the customer any information given by the principal which may weaken the principal's position in negotiating unless the agent has permission in writing to do so. So this one we come back to, do you have offers on your home? Okay. This is a material fact that could weaken your seller's position. If you don't have permission to tell the agent who asks you, you should not be telling them. I had an agent he didn't say whether his seller gave him permission, but I asked him, he had it under contract with a time, or it was active with a time clause. So they had a contract in place, but they were still asking for more offers because there was a contingency on that sell. And I asked him, I said, does it make sense if I write an offer at this price? And he came out and told me the exact price that the offer was there and what the contingency was, and suggested that I write an offer and bring it to him. Now, could that hurt the position of the client? Absolutely. Could it benefit the client? Absolutely. And I don't know whether he had permission to tell me that or not, but I'm finding that most of us don't get permission to do those things from our client. We just do them. And that's where we can run into problems with confidentiality. We might think it's a benefit, but if somebody convinces them otherwise and we didn't get permission from them, then that could change their opinion of whether it's a benefit or not. So it's always best to get permission in writing before that. Now, the question that I have all the time is, I talked to them on the phone and they gave me permission. Okay, this has to be writing in Utah. Everything we do, every agency, a relationship, everything that we establish has to be in writing. So if I have a phone conversation with my client and they say, yeah, you can tell them the price, or yeah, you can tell them we have multiple offers. Yes, you can disclose these things. What I want to do is at the end of my conversation, I'm going to say, I'm going to send you a quick email of what we talked about today. Just respond that I didn't miss anything. Okay, so then I'll send them an email and I'll say, hey, we just talked about X, Y, and Z. Just want to make sure I didn't miss anything. Did I miss anything, or is this okay with you? And they'll respond with, yes, this is okay, or no, you missed this. And then I'm going to take that email and I'm going to put in my dot loop for my written authorization to do something. So it's not an excuse for us to say, well, yeah, I had that conversation with them, but I didn't write it down, but they told me this. We need to be the one initiating the email response so that we have it in writing for that. I find that one happens more time than not. And the interesting thing is, I'll have a client call me up wanting to get out of a contract and they'll say this story, then I'll call the agent and I'll get a totally different story. And unfortunately, if it's not written down, then it's up to interpretation, and they usually will side with the public when you're a professional and should have it written down. So you're not going to win if
Jason?
Yes.
No, I was just going to say, I really like how you worded that, because sometimes when I do that, I always feel like, oh, it looks like I'm just covering my rear end, but I like how you said that. Make sure that I didn't miss anything. That's really good. It's making sure that I am being, including all the things that we've talked about, and that's okay. Instead of, I'm trying to cover my butt, so I really like that. Thank you for that. I wrote that down.
Yeah. And really, what's interesting about it is there's sometimes where you missed something they said, or when they read back what you said, they'll respond with, well, what I actually meant was this, and it's just better communication between the two of you. So, yeah. Okay. Reasonable care and number 5, the reasonable care and diligence. This I find violating when, they can come back and say, we're really not taking care of them. We're not listening to what they need. That's just one of those things where we need to be attentive with our clients if we're gonna work with them. So That one will fall under the communication side of it. That's where I see the complaints the most. Oh, they didn't take care of my needs. They didn't get me an inspection. The one that I see the most, and maybe you guys have done this before, but you forget to do the due diligence checklist and the buyer's due diligence signed. We don't get it signed until after the due diligence deadline. And then we go back and say, well, yeah, these are the things I need to get fixed. Just get in the habit of getting those signed before your due diligence deadline, so that if they want to do inspections, they can, or if they want to, do any more research, they can do that. But if you have them signed at the closing table, which I unfortunately see a lot on the compliance side, you're running into this reasonable care and diligence. You're not doing your duty in that sense. Now, number 6 is holding safe and accountable all property or money. It's really important that you're making sure you know where the earnest money is going. In our contract, it specifically says it's going to be deposited with a brokerage. So if you decide it's going to go to a title company, which is fine, you need to do an addendum to your contract. What I'm finding, I found one last week, a $16,000 earnest money check deposited with title company with no reference in the contract that it was going to be with the title company. So that could be breaking some of our fiduciary duties if we're not diligent in figuring out exactly where they're supposed to go. Okay. Any questions on those fiduciary rules? Let's see. I think there was one more thing that I wanted to go through with you. It's whenever you're representing somebody, it's our responsibility as agents to disclose that we have an agency relationship. So if I represent a seller and I'm holding an open house and somebody comes in, I need to disclose that I represent the seller. If you go through a conversation with that potential buyer that comes in there thinking, hey, I want to take on this buyer, I want them to work with me, which is kind of the point of the open house, we still have to disclose that you work with the seller. If the buyer goes away from the transaction not knowing that you represent the seller, and then it comes out that you represent the seller and they were asking you different questions and telling you different things, you could be in violation of not disclosing your agency. So that's the one I see the most is in open houses, but we need to disclose that, yes, I do represent the buyer. Yes, I do represent the seller in that transaction. Okay, the last thing I want to talk to you about is implied agency. Implied agency is one that can get us in trouble the most. Basically, what it means is I didn't go in and I didn't sign about an agency agreement with them, but I'm acting as an agent. I'm giving advice. I'm doing things that an agent would normally do in the transaction, but they don't have a signed contract. I've seen that with when we wait until we're writing an offer, but we've shown them 10 different homes before we even wrote the offer. And so we've got this implied agency. And this is what the rule says for implied agency, which I thought was kind of interesting. It says, when agents advise a customer in a manner detrimental to the client's best interest, they are creating agency by implication and therefore undisclosed limited agency. So if you give advice to somebody and that advice is followed and it's the wrong advice, the courts are going to look at that as you've had established agency with them. So you have to be really careful that what kind of advice you're giving to people when you're working with them. And that's why it's really important to sign agency agreement and establish those ground rules. So it's basically saying agency will establish these ground rules. These are what I'm going to follow. These are what you're going to follow. If I don't have disclosed agency and I'm just giving out information, just talking through the process with somebody, and then they take that information and they use it, then the problem we run into is that they can be liable for it. So there is an example that kind of runs into this category. They didn't have agency, so it was implied agency. This was back east. Like, I don't think it was like East Coast, but like Arkansas, Kansas area. I think it was in that area. An agent was representing the seller, and a buyer called up and said, "Hey, can I come look at the home?" And the buyer comes into the home, and while they're in the home, they were talking about the different thing, and the buyer really liked the home and they want an offer. And so the buyers asked the seller's agent in the home, they said, do you think your seller will take $20,000 less? And the agent said, I would write up the offer. We'll see what we can do. And so then they went back and they wrote up the offer. Well, what the agent didn't realize, which I hope all of you guys know nowadays, that everybody records things in their homes. There's usually cameras in all homes, and you're not going to get away from the sellers not knowing. Well, the sellers heard this. They heard it on the video. They had proof of it. They didn't say anything to their agent. They accepted the offer as is, and they went through to closing. As soon as they closed, they filed a lawsuit against the agent about breaking their fiduciary duties and representing the buyer, or giving them the information they needed. And the courts actually found in favor of the seller and fined the agent the $20,000 difference, and said, because of the advice you gave the buyer and you're not representing the seller's best interest, they lost on that one. So it's really important that we, one, establish who we're working for, but two, that we do keep those fiduciary duties and we follow them through the whole process. Otherwise, we can find ourselves in a legal battle that is not a fun thing to do. Okay, so that's agency. That's some of the pitfalls we can run into. Moral of the
Hey,
story.
Jason,
Yes.
just really quick, what could you have said differently than what that agent said, instead of, just putting, I hear that often. I'm not sure if that's like, the best thing to say, but what would you say differently than that?
In that scenario. So
Yeah.
we know what my seller is willing to take, which is the asking price. So whenever somebody asks me, will your seller take less than the asking price? I will always just say, well, I do know that if you give us a full price offer, that they will accept that. So you just have to look at it as, I'm not giving away my position, other than I know my seller is willing to take the asking price.
Jason, can you say something like, I am not sure what my sellers will accept. You can, I have not, something about, I can't disclose what they will or will not take, or I don't know what they will or will not take. You can put in an offer that your buyer is willing to submit.
Mm-hmm. Yeah, put in an offer that you're willing. I'm not sure what my buyer or seller will do. And exactly what you said. I like it. Yeah, it's just not confirming, oh yes, put that offer in. And in this particular case, it was like, yeah, I think you should put that offer in. You should not be coaching someone else on, what they will and will not take. That's where we run into the problem with limited agency, is we know what the seller will take. We know what the buyer will take. We have to be limited, and we cannot fully disclose what each client is doing. We have to take a step back from there. And if we say words that hurt our client's position, that's where we can get in trouble for it. So Christine, you're right. That's a great way to say it.
Thank you.
Okay, any other questions? Okay, so moral of the story, get your agency and follow your fiduciary duties, represent your client well. Oh, actually, I did want to say one more thing, because we had this come up. Oh no, we talked about it. You cannot. Oh no, we didn't talk about it. So I had an agent just 2 days ago. They wrote, they represent the seller, and they decided that they were going to buy the property from the seller. So now they are limited. Can they do that?
Only
Will you
with,
say that one
the-
more time?
Okay, so I represent the seller. I have a listing agreement with the seller and I decide that I want to buy the property. So I'm going to be limited agency and buy the property from my seller.
I don't think you can do
You
that.
cannot.
Heck, no.
Heck no. Thank you, Amy. Yes, you cannot. You cannot be a principal in a limited transaction. How are you supposed to be limited when you know one party's full process? So I had a contract just come across the desk just yesterday in our office where one of the agents represents a seller and now they are the buyer. So you have to get rid of the seller's, you can buy your seller's property, but you need to dissolve the agency relationship and cancel that prior to writing an offer. Otherwise you will be breaking the law. So do not be a principal. And the one that gets confusing is if you are, let's say you're buying it with an LLC and you're just a partner in it and you have a 5% partnership stake in that company or a 1% stake in that company, you cannot represent as a limited agent in that. Okay. Any questions?
But Jason, that's so easy to do because I have done that before. All you do is you cancel the listing
Mhm.
and have a discussion with them and just do it the other way.
Yeah, you can definitely buy the property. You just do not have, you just cannot do limited agency. So you need to cancel that contract with the seller and then go ahead and be the buyer and work through it, but you cannot be limited. Okay, you guys have a great week. If you have any questions, reach out. We're always here to talk through some scenarios if you have any questions.
You're awesome. Thank
Thanks,
you.
Jason.
Yep, thanks.
Thank you.